The third, I love it. That one often gets overlooked, Matt. I love it. That's a very good one. It looks like our panelists are getting set up now. We probably got a few, maybe one more minute until we get started. The first or the ninth?
Okay, we're going to get started. Sorry, Brian. Hi, everybody. How are you doing today? Well? Good. Okay. Yes, there's call and response here. And you all, nice to have you join us as well. If you want to move up, you can, but you can also stay in the back row too. Any of you guys can join as well. My name is Carey. I'm the Chief Learning Officer here at the National Constitution Center. Really excited to be here today. We're happy to have you all in this exhibit. This is the Reconstruction exhibit at the National Constitution Center, and it looks closely at the 13th, 14th, and 15th Amendment. We're also excited to have all of our online students with us today in class. So really fun. We're mixing all the worlds together, but I get to do this with a great friend of the Constitution Center, Kermit Roosevelt. So can we all, since we're in person, give Kermit a real round of applause? And not a weird virtual one like we're used to.
Thank you.
So Kermit Roosevelt is a constitutional lawyer. He teaches all about con law at University of Pennsylvania at the Carey School of Law, but he's also an amazing expert on the Bill of Rights and the Reconstruction time period. So do you guys know what day it is, what special day it is today? You don't know? What is the grouping of amendments that most people talk about all the time? The Bill of Rights. Guess what day it is? It's Bill of Rights Day today. So this is the day that many of the first 10 amendments were ratified into the Constitution. It's a big day. But what we're going to find out today is they don't have the impact that we think they did until a little bit later during Reconstruction. So let's get us started, kick us off. People online, if you have questions, feel free to send them into the chat. My team is going to text them to me. So when we get towards the ends, we'll ask questions. And for you all, if you have questions towards the end, you get to just ask them out loud directly to Professor Roosevelt. So it's fantastic. So thank you so much for being here.
Thank you for having me. Happy to be here.
So tell us about the Bill of Rights. Why did, the Constitution was ratified? A Bill of Rights is so quickly added afterwards. Can you give us the story about why we needed a Bill of Rights and what was the kind of intent and purpose of those first 10 amendments?
Yeah. So why is the Bill of Rights added so quickly? How does that happen? It happens because it's under contemplation even during the debates about ratification. So a lot of people want a Bill of Rights. Some states actually, when they ratify the Constitution, they try to make their ratifications conditional on the addition of a Bill of Rights, which maybe is effective, maybe not. But in any case, people think we need this, and they kind of expect that they're going to get it. So why do they think that they need it? Because what the Constitution is doing is creating a much more powerful federal government. So before the Constitution, we had the Articles of Confederation, and the national government there was very weak. It couldn't do very much. There was a Congress, but there was no president, there was no courts. Turned out it couldn't make the states cooperate the way it needed to. So we're going to make a stronger national government. That's what the Constitution is doing, but this worries people because they're thinking about the last war. So sometimes I say Constitution drafters fight the last war. People are thinking about the revolution. And why did we have the revolution? Because the national government was too powerful and it was oppressive. That was the British government. And so in the minds of the drafters of the Constitution, they're thinking if the national government is too strong, it might oppress people. And states can help. So states can help defend the liberties of their citizens. That's sort of what happened during the revolution when the state militias fight off the redcoats. And there are structural things that we're doing with the Constitution to try to make the federal government less dangerous to liberty. So we give it limited and enumerated powers. It can't do just anything it wants to do. And we separate those powers among the three branches of government, and they're supposed to check each other. And all of this is supposed to protect individual liberty, but it's not enough. People are still worried that the national government might become a tyrant. So the Bill of Rights responds to that in two ways. One of which we think about, one of which we've sort of forgotten. One thing it does is it gives individuals rights, which is what we think about now. Individual liberties, things the government can't do to you. The other thing it does is it strengthens the states because the states are viewed as these trusted defenders of liberty.
I think it's so important the way you kind of like laid that out. So the Constitution, 1787, it's brought in, it's a reaction in some ways to an oppressive government. So you're going to naturally swing, and maybe too far with the Articles of Confederation, to, no power in that national government. So we're always trying to, like with everything in life, kind of balancing things. And the idea is that the Bill of Rights is there to ensure that the people, through representation of the state, are not stepped upon. Is that correct?
Yeah. Yeah. So the idea is we need to protect people from the federal government. And one way we do that is limiting federal power. Another way we do that is individual rights. And another way we do that is empowering the states. So in a couple of instances, there are Bill of Rights provisions that really are designed to let the states stand up to the federal government.
And it's kind of fascinating because when we think about the Bill of Rights, at least when I think about the Bill of Rights today, I really think about it as, oh, it's about me, a person, and what the government, state government, local government, or national government really can't do to me. But then it's really about the states supporting you and representing you. But that's not really the case. Like the states aren't really, let's be honest. So the Bill of Rights is launched. It's out there. It's ratified. Are the states really protecting all of the people in their state?
Well, no. So the states certainly aren't protecting all of the people in their state. They're not protecting certain classes of people very well in terms of political rights. If you don't own property and you're not a white male, you don't have a lot of political rights. If you're a woman, you have very fewer rights. And of course, there are people who are being enslaved. So there are provisions in the Bill of Rights that protect individuals against the federal government, but there's very little protection against the states. And this is sort of interesting. Maybe this is a moment to give my puzzle. So I don't know how legally educated people in the audience are, but if I ask you for a Bill of Rights case, like name a case about free speech, and I'm not really going to ask you because I don't know if it would work with this audience, but I ask my law students this who come into class with some sort of background legal understanding, and they'll say something like, hey, New York Times against Sullivan, that's a famous First Amendment case. It's about criticizing the government. Or maybe the students are familiar with the cursing cheerleader, the recent case about the cursing cheerleader on Snapchat. There's a First Amendment case. Or if I'm like a Fifth Amendment case, the right to remain silent, most people will come up with like Miranda against Arizona, your Miranda rights. And then I ask them for all these cases, and then I say, wrong, 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 because none of those is a Bill of Rights case. None of those is from the first 10 amendments. They're all from the 14th Amendment.
We all know those cases, by the way. Just kidding. I appreciate that you start off class by saying, no. They're really building up their positivity there. I think this is really powerful because that you said earlier that the states are stepping on the rights of the individual. And then also that the Bill of Rights in this idea of what we think it is today really doesn't take hold until the 14th Amendment is written. And what year is the 14th Amendment written into the Constitution?
1868.
I told you I'd ask you easy questions. It's a really powerful amendment, but that's almost 100 years later. So for 100 years, are we really at all tapping into the Bill of Rights in any way?
Not really, for a couple of reasons. So one is the things that people said about limited federal power and division, separation of power among the branches was sort of true. People didn't have that much interaction with the federal government, much less than they have nowadays. So the federal government didn't have a lot of opportunity to violate people's rights. It just didn't happen that much. So the Bill of Rights wasn't as significant. Most of your interactions are with your state government, which can violate your rights. But the Bill of Rights doesn't protect you. And there is an early case about that, Barron against Baltimore, where the Supreme Court says what seems pretty clearly correct. The Bill of Rights is about the federal government and not the states.
So it's really focusing on the federal government. When you look at the words and you read them again, the First Amendment, Congress shall make no law. They're not saying the state governments, they're saying Congress. That's the federal government is not a law that takes away your freedom of speech or freedom of religion. So are there states that violate people's freedom of religion or choose one religion over another?
Yes, so that's a really interesting point about the First Amendment and the Establishment Clause. When the Establishment Clause is written, there are plenty of states with official religions, which we would now call establishments. And does the Establishment Clause strike them down? Certainly not. Actually, what the Establishment Clause does is it protects them. So the Free Exercise Clause is written clearly as an individual right. So Congress can't restrict your free exercise of religion, and that's the right that you have as an individual. But the Establishment Clause says Congress shall make no law respecting an establishment of religion. And one thing that means is there can't be a federal establishment. Congress can't say this is our national religion. But the other thing it means at the founding is Congress can't interfere with state established religions. So the point of that, again, is we're preserving state authority so that the states can protect the liberty of their citizens, which of course they're not doing for everyone.
Fantastic. So another question that I have for you, and sorry, this is going a little kind of existential in a way, when I go big picture on this one, because we're in the Reconstruction exhibit, looking at that time period between, at the end of the Civil War, or at the end of the Civil War, the 13th, 14th, and 15th Amendment, and you can give us like kind of ballpark of those dates on that. But one of the questions that I have for you is, when we teach about American history, when we teach about the Constitution and we're telling stories about it, so often a lot of our stories start with Madison. They start with Bill of Rights. They don't always lead with the Reconstruction time period. And you just told us this 14th Amendment is really what makes that, original Bill of Rights so powerful. So what story do you lead with when you're teaching about American history and the rights of individuals? What's your go-to story? What's the story you think we should be really learning in classrooms across the country today?
Well, so chronologically, I think you do start with 1776, and I do that. I start with the Declaration of Independence. And then you talk about the original Constitution. But what I try to do is I try to show people how the Constitution you get in 1787 or 1791, and even the Declaration of Independence as it's understood in 1776 are very different from the way that we understand them now. So we've got a constitutional system now where the federal government has a lot of power and the federal government protects people's rights. And you have federal constitutional rights that protect you against state governments, because it turned out states were not that trustworthy in terms of protecting liberty, at least for some people, right? And those people didn't really count at the founding, which is why we're okay at the founding with the Bill of Rights only restricting the federal government. But America changes, and the new robust system of federal protection for constitutional rights that we have, we often think of that as though it's sort of the founding vision and Madison and the founding fathers, but it's really not. It's all from Reconstruction. It's all from the 14th Amendment. And so the story that I tell is really, we've got two different constitutions. There's the 1791 Constitution with the Bill of Rights, where the federal government is, pretty much hands off. And then we've got the Reconstruction Constitution, where the federal government is actually coming in to protect your rights. And if you think about the big important cases that everyone loves, where we're like, here, the Supreme Court is standing up for this important right, almost all of those are 14th Amendment cases. So, Brown v. Board of Education is maybe the heart of our constitutional understanding now. As I said, New York Times against Sullivan or Miranda, all of those cases are 14th Amendment cases. So the Constitution that we think of when we think of the Constitution is really Reconstruction. It's not the founding Constitution.
Okay, so now I want to have you break down, tell us what the 13th Amendment is in a nutshell, what the 14th Amendment is, and I know that one's harder, and then what the 15th Amendment is. And then I guess the question is, why? Why is it such a different Constitution after those three amendments? What's packed into them that gives that kind of change? And does it happen right away?
So the 13th Amendment bans slavery, and it gives Congress the power to enforce. So you can think of the Reconstruction amendments as in some ways an inversion, like a flipping of the Bill of Rights. So the Bill of Rights, I was saying before, puts limits on Congress. First Amendment says Congress shall make no law. And in some ways, it gives authority to the states. It protects state establishments of religion. The Second Amendment protects state militias, with the idea actually that the militias will be a military counterweight to the federal government. And then the Reconstruction amendments flip that. They're like, no state shall. That's the 14th Amendment. Puts limits on the states and empowers Congress, because they all say Congress can enforce this amendment. So we've got a total inversion of the views about the states and the federal government, right? We're giving power to the federal government because we trust it to defend liberty. Because again, Constitution drafters are fighting the last war, but this time the last war is the Civil War, where the federal government is fighting for liberty and the states are the oppressors.
And we hear that in, did you do the 15th Amendment too? Sorry, before I just jumped.
No, I actually only got to the 13th.
Oh, sorry,
So
you did.
The 13th Amendment, the 13th Amendment bans slavery, right? Which is very important, but only takes you so far, because then you have the question, what is the status of the formerly enslaved in the American community? Are they members of the American political community? Are they citizens? And that is something that the former Confederate states really resisted. So having lost the Civil War, they accepted that slavery was over, at least in name. They tried to restore it in all but name. The Reconstruction Congress wouldn't accept that. That's where the 14th Amendment comes from. And the first sentence of the 14th Amendment reverses the Dred Scott decision by saying any person born in the US is a citizen. That's about the rights of the formerly enslaved. And it's saying, yes, they will be members of the American political community, which the former Confederate states are not willing to accept. And that's why Congress actually wipes out their governments with the Reconstruction Act, puts the South under military control, and rebuilds those states from the ground up, really with a different political community. They get new constitutions. They are, I like to say, new states. So it's really sort of, as Lincoln said, a new birth of freedom. You could almost think about it as a new nation created with Reconstruction. So formerly enslaved will be US citizens. And then they go on and gives them rights, and it gives Congress power, and it says some very important things about Confederate debt and claims based on emancipation. And then the 15th Amendment is what's supposed to make it all work going forward, because the idea is we're going to have racially integrated governments in the South, respecting people's rights equally, providing government services in a way that they never did before. And for all of that to work, we need multiracial democracy. So the 15th Amendment bans racial discrimination in voting, where the idea is now it's going to be self-sustaining, but it turns out it doesn't work.
And that's where my litany of questions are going to come from next. So 2 questions on that. And we love primary resources here. And we just launched a new founders library. And of course, people, greats are in there, like Martin Luther King Jr. And we look at that and we hear from Frederick Douglass, from Lincoln, from MLK, and this is in your book too, about that call for the federal government standing up for freedom and standing up for equality. That's a huge shift from the original belief that that federal government was dangerous, needed to be protected. And then you switch to, no, you're the ones that are supposed to come in and protect us. So when we think back of understanding our Constitution as a whole, which lens do we take? And depending on which part of the Constitution?
Well, yes. So which lens do we take? It's a super interesting question. And to be honest, to some extent, it's a partisan question. So there's a Columbia law professor named David Posen, who I think is brilliant. I really like him. And I was talking to him last night, and he said, we just did this big data analysis of political rhetoric by presidents and members of Congress, because everyone likes to talk about the Constitution, it turns out, which isn't surprising, right? Because we're all committed to the Constitution. We think our Constitution is great and so on. I mean, I try to complicate that a little bit in my constitutional law class, but in our political rhetoric, our Constitution is great. But it turns out that people like different parts of the Constitution, and there's a very strong partisan divide there. So one party, maybe I just won't say who they are. One party talks about the 1787, 1791 Constitution. And when they talk about constitutional provisions, it's almost always those ones. And then the other party almost always talks about Reconstruction, 13th, 14th, 15th Amendment. So we've got these 2 very different visions out there. And the lesson to take from that, I think, is there's still a tension, right? There's still a battle going on between sort of the vision of the founding and the vision of Reconstruction, because we do get the vision of Reconstruction, but then of course, the federal government doesn't stand up enough. Black voting rights are taken away. The project of Reconstruction fails, and it's submerged for almost 100 years. You know, you get Jim Crow, segregation, all of these things that are not consistent with the meaning of the Reconstruction amendments.
And the federal government itself pulls out, as well as does not enforce the amendments that they had just in the courts as well, correct?
Yes. Yeah. So, every branch of the federal government fails, really. The Supreme Court, too. The executive, Congress, there's attempts to pass enforcement legislation, but America as a whole does not have the will to face the conflict that's necessary to make Reconstruction stick.
Okay, now 2 questions on that data, because if you don't know me, I love data. Like, I'm super obsessed with analyzing data. I think it's so interesting. So one is that would be an interesting thing to add to a dating app, that you like pick what part of the Constitution.
Your favorite amendment.
Exactly. What does that tell you about? We have a running class activity where we always ask, what's your favorite amendment? But we tend to ask it as, what's the one you're most obsessed with now? Because at least for us, it's constantly pivoting and changing. And even one of our team members is obsessed with the Third Amendment, and not many people can say that. But he's made it very interesting. He writes our blog. He's our chief editor. I'll get that in a minute. To my question is, earlier, before we started, we were talking about how this is the first permanent exhibit in the United States dedicated to telling the story of Reconstruction. That is amazing, but also sad, because this is a huge moment in American history and we don't talk about it enough. So I'm just wondering, on that data point, is there a need, and again, my background's education, is there a need for everybody to really fully understand Reconstruction, to say, maybe I value it less because I didn't learn about it in school, which, we can talk about the history of Reconstruction is also the history of hiding what happened during the brief time period of Reconstruction and changing the narrative. So is your data skewed because of lack of knowledge?
I think maybe. So I think that we teach Reconstruction terribly. But it's interesting, you offered 2 possibilities before, sort of misrepresenting and hiding. And what's happened, I think, is we started out misrepresenting. So from, the 1870s through the 1960s, Reconstruction was presented as a bad thing a lot of the time. It was oppressive, it was overreaching, and really what we should have been concerned about was creating unity among white people faster and healing the wounds of the Civil War. And Reconstruction was an obstacle to that, and it was sort of a bad thing. And then, in part because of the Civil Rights Movement, I think, and what people actually call the Second Reconstruction in the 1960s and 1970s, that story wouldn't work anymore. And we started saying, now we are committed to the values of Reconstruction. We're committed to equality. America is really founded on equality. But it's still divisive to point to Reconstruction as the source of that value, because there are a lot of Americans who still look back on the Civil War with sort of complicated feelings. And if you're like, identify with the Union Army in the Civil War, they are our heroes, you get a lot of people who react badly to that. So what we did, I think, was we just stopped talking about Reconstruction so much. And we're like, our values are equality, but it comes from the founding, because that was supposed to be something that could bring people together. So we changed the story. We keep the values of Reconstruction, but we start talking about 1776 and the Declaration of Independence as sort of a placeholder for those values. Even though my theory is, if you look at it closely, that's really not what the Declaration is about.
Yeah, and I think it can be really tricky when understanding kind of people's perspectives and the knowledge. And there's a Signal survey that just came out, research data, and they were asking parents about what to teach students in school and across the board. And they went to politically active parents on all sides. And what they found was every single parent agreed on one thing, and that is the need for more civics and history education. So that is like a unifying quality of everyone that comes to the understanding. It's, I guess my question is always like, what story are we leading with? What story do we tell? And what story are we choosing not to tell? And when you don't know a story is missing, it's hard to say, well, what about that? As we think about, the 13th, 14th, and 15th Amendment, and we moved kind of to the next, 1900s on, how do we see the Bill of Rights change explosively?
Yeah.
And how do we, like, what are some of those key cases or those key stories that really connect the Bill of Rights and the 14th Amendment? And is it like a light switch that all of a sudden all the Bill of Rights are now incorporated, or does that happen gradually over time?
It happens gradually, and it starts in the 1900s. So it does start relatively early, The Supreme Court is looking at the 14th Amendment and the Reconstruction Amendments and sort of wondering what to do with them. And, in the early Reconstruction era, you get some cases where the Supreme Court is doing what it should be doing. So there's an early case that strikes down a law that excludes Blacks from jury service. There are some good early decisions. Then there are some sort of puzzling ones. And as the years go by, the 14th Amendment turns into a fountain of rights for corporations, and it's protecting economic interests and capitalism and employers, which is not really what you would have expected. But it does start doing things. And so you get cases where the Supreme Court says, I wonder if this Bill of Rights provision is somehow contained in the 14th Amendment. And they go through provision by provision in different cases over the years. And basically with no exceptions, Seventh Amendment right to jury trial in civil cases, but with almost no exceptions, they end up saying, when the 14th Amendment says that no state shall deprive a person of life, liberty, or property without due process of law, it actually means they must observe the Bill of Rights. And this brings the Bill of Rights forth sort of explosively for two reasons, I think. One is states are violating those rights more than the federal government did. That's one of the things I said. Federal government does violate those rights, and it did in the founding era too. So like the Sedition Act sure looks like a First Amendment violation now. Maybe they had a different understanding of free speech then, but you don't get the Supreme Court pushing back against the federal government as much because the Supreme Court tends to sort of move in concert with the federal government, and the federal government is powerful. So Supreme Court versus the federal government, that's one branch versus two branches, maybe. Supreme Court versus the states. If the federal government is on its side, the Supreme Court wins that battle. So when the Supreme Court wants to articulate a constitutional right, if it's saying states, you can't do this, it can really go forcefully. And that's what we see with some of the early cases about the Bill of Rights and the states. You get very robust expressions of these rights from the Supreme Court because it's a context in which the Supreme Court is institutionally more capable of announcing a broad rule and then making it stick.
Fantastic. Now, I will point out the Constitution 101 class that we have. You can unpack all of these. There's an entire week-long worth of material on the 14th Amendment. And to be honest with you, we could have made it like 15 weeks. But there's also one on the First Amendment, the Bill of Rights, the Fourth Amendment, and unpack a few because there's so many good stories behind this. I'm going to go to some of the questions that I'm getting text from our online audience, but I also want to respect all the lovely humans in front of me. Do you have any questions you want me to start with? You want to just ponder them? Okay, you can do that. Right, on.
You said that's not what the Declaration of Independence is about, in my opinion. And then there was a very pregnant pause, and then it was reported.
I'm going to repeat that question for everybody online. I love that you picked up on that. Professor Roosevelt said, that's not what the Declaration of Independence is, in my opinion. And then, as you pointed out, there was a long pregnant pause after that, meaning like, wait, what's on there? So what do you mean? And thank you for bringing that, because I wanted to talk about it. It's a great book. Since
you mentioned it, this is a book that I just published, which is why I'm sort of obsessed with the idea. But what I was hinting at there was my view that the Declaration of Independence is really about independence. It's about the independence of states. It's about the ability of one political community to separate from another and govern itself. And the phrase, all men are created equal, is part of that argument, but really it's designed to say no one is entitled, no one is chosen by God to rule over others from birth. Right? All men are created equal. No one starts out in a position of legitimate political authority over anyone else. So it's a rejection of the divine right of kings. It does work that you can identify pretty clearly if you set out the way the argument of the Declaration works, but it doesn't mean that the government should treat people equally, which is what we now think. It doesn't mean that the government must respect the rights of people who are outsiders to the political community. So it doesn't actually mean that slavery is wrong if you're enslaving outsiders. So interestingly, like a lot of people, were like, hey, the colonists are saying King George is trying to make us into slaves. That's a terrible thing. But at the same time, they're enslaving outsiders. So isn't that an obvious contradiction? And the answer is it's not. So the theory of the Declaration is people form governments to protect their rights. If the government then enslaves the people who formed it and violates their rights, that's a terrible thing. Obviously, it's going against the purpose of government. But if the government violates the rights of outsiders, people who have not formed the government, then maybe that's okay. I mean, the Declaration doesn't say that is not okay. So there's a different reading of the Declaration that emerges. And historically, you can see this happening in the 1820s, basically, and it happens because of abolitionists. So the reading of the Declaration we have now, which is on the walls all around here, people saying the 14th Amendment is what puts the Declaration into the Constitution. Yes, but it's the 1820s Declaration. It's not the 1776 Declaration.
I think it was, I'm not sure if this is right, but was it Dickinson that said that King George is making us enslaved?
Well, a lot of people did. Jefferson did. Yeah.
So second question on that, though, and again, this is from your book and I really like it. Malcolm X pulling another part of the Declaration out and saying, hey, if the government is not legitimate to us, we have a natural right, which is one of my favorite things to talk about is natural rights, the right that no government can take away from you because you exist no matter who you are. We can flip the table and go for insurrection. The Declaration is also stating that, correct?
Yes. I mean, that's what the Declaration is really about, the right of rebellion, right? If the government is mistreating its citizens, they have a right to rebel. So Malcolm X says this in the context of criticizing Martin Luther King and the March on Washington and the I Have a Dream speech, because King is there saying, in the name of the Declaration of Independence, people should be treated equally. We should all, hold hands and move forward together. And Malcolm X was like, that is not what the Declaration of Independence is about, which, I mean, I think he's got a more accurate reading there of at least the original Declaration. He's saying what the Declaration is about is the right of rebellion. And I think he's right. Now, who else said that? Well, the Confederates said that. So Jefferson Davis and John C. Calhoun said the Declaration of Independence is on our side because we joined the Union with certain expectations for various purposes. Now the federal government is turning against us and denying us the rights that we were promised when we signed up, because the 1787 Constitution protects slavery in various ways. Now Abraham Lincoln and the Republican Party are in control of the presidency, and they do want to end slavery. So the Confederates say the Declaration of Independence authorizes us to leave the Union.
And I think this is so fascinating because our modern conversation across our country is, what's the reading of these documents and what time period do we read it and how do people change and understand these over time? So it's fascinating that you're kind of showing these moments and different people in the past that are doing the same thing that we're all doing today to trying to understand what do these mean and how do we interpret them?
Yeah. And the other thing that's fascinating about this, I think, is to see the way that the significance of the argument changes over time. So if it's 1861, and you're saying the Declaration of Independence supports the Confederates, you're probably a Confederate. If it's nowadays, maybe you're saying something different. So the argument of my book really is something I kind of hinted at before, but I say it a lot more strongly in the book, which is we can think about two different constitutions. And we can say, you know what? The Declaration of Independence did support the Confederates. And maybe the 1787, 1791 Constitution actually supported them too. And now we have a different constitution, which is better. And this is really what we should feel a connection to, the 14th Amendment and Reconstruction.
Okay, now I promise I will get to questions online and they're in front of me because Madison, our awesome team member, is texting them to me. So Ben would like to know, can you talk about the influence that early state constitutions had on the Bill of Rights? So where did they get the ideas of the Bill of Rights?
Yeah, so a bunch of the Bill of Rights provisions are drawn from early state constitutions. They're drawn from things like the Virginia Declaration of Rights or the Magna Carta. A lot of them, and this isn't what made people think of them necessarily, but it's what made them seem significant. A lot of them are also responding to abuses by the British Crown. So one interesting thing to do is you can go through the Declaration of Independence and look at the bad things King George has done. And then you can find responses to a lot of those in the Constitution. And sometimes they're in the original Constitution. So King George has made judges dependent on his will alone for their salaries and tenure in office. So when the Constitution creates federal judges, life tenure, their salaries can't be reduced. But then other things get responded to in the Bill of Rights. So King George has quartered troops among the colonists, which they didn't like. And that's what gives us the Third Amendment.
I love any activity that does cause and effect, because sometimes we think it came out of nowhere. It didn't. It was totally like every human being. It's a reaction to a horrible experience they had with the government. So they're going to try to fix it the next go around. And then activities actually in our curriculum too. There's a matching activity. You can match it up. So I'm excited about that. Next question from Ryan. Can we discuss some of the key drafters of the constitutional Reconstruction amendments? Sorry. We know the names. We talk about Madison. We talk about so many famous people from the founding, 1787. Could you give us some of the names of the second founding?
Yes. And so these are people who I think we should view as central or more central to the constitutional order we have. And this is mostly the radical Republicans in Congress. So John Bingham, hugely important in the drafting of the 14th Amendment. Thaddeus Stevens, Charles Sumner. I would put those three really high in the list of American founders.
And there's some artifacts from them for everybody in the room right around the corner over by the carpet bag. You'll be able to see some pieces of that were related to Sumner. Now, last question is from Betsy. She sent it to me earlier, and it's perfect because the words are right there: privileges and immunities. So there has been a lot of discussion in the courts recently on privileges and immunities clause. And could you give us the backstory of the privileges and immunities clause, but to help answer her question? But will it regain a constitutional authority in some sense? And could you break down for us what it is, kind of how it lost some power? And do you think it's going to come back into play?
Sure. So the privileges or immunities clause, with much of the 14th Amendment, it's a little bit unclear where it came from and what people thought it would do exactly. Probably this comes from Article 4. So there's a set of rights that states must give to visiting out-of-staters. The privileges or immunities clause is supposed to do something like that for in-staters. So the idea is the original Constitution protected citizens from discrimination by other states. And the Reconstruction Constitution is going to protect people from discrimination by their own states, because this is the new lesson of the Civil War and Reconstruction. States will oppress their own citizens, right? Particularly once you've made the formerly enslaved into citizens, the states are going to be trying to oppress them. And we want to stop that. So privileges or immunities, this is giving you a set of federal rights that you can assert to protect yourself against the states. Rights guaranteed by the federal Constitution, the states can't take them away. But what are those rights? Well, it's not very clear. And in an early case, the Supreme Court gives a very puzzling reading of it that basically makes it sort of pointless, which everyone thinks is wrong, but there's less agreement on what is right. One thing that many law professors do think, though, is that if you want to know how you can assert the First Amendment free speech right, say, against the states, the answer is it is one of the privileges or immunities of citizens of the United States. So that this clause, the privileges or immunities clause, should have been what the Supreme Court used for what we called incorporation, which is the process by which the original Bill of Rights provisions become rights against the states. Instead, the Supreme Court used the due process clause, which is a little bit weird. And for a long time, law professors have been saying, oh, you should go back to this. You should go back to the privilege or immunities clause. The Supreme Court has sort of considered the idea, but not seemed very enthusiastic about it because it would change a lot of their precedents. And no one has really been able to explain what the gain would be. How would things be different? How would things be better? Now, one way that things might be different or better, Akhil Amar has said this, is that maybe Congress can declare what the privileges or immunities of US citizens are, so that if you start switching to this clause, then Congress, using the power that Section 5 of the 14th Amendment gives it, can maybe go a lot farther.
So it would be a multi kind of federal government effort on that. It is pretty fascinating. It's also when you hear Professor Roosevelt kind of walk you through that, you can see how the amendment itself is broken down into different sections. And then to prove your case or to explain your reasoning in deciding a case, a judge or a lawyer will say, I'm going to take this section, I'm going to give you reasoning behind it, and I'm going to try to make an argument that is supported by either past law or by precedent or by law that is written by Congress. So you watch the process when we unpack these as well. So as we wrap up today, I also just wanted to point out that there's another huge movement in our country that is the next exhibit that you can walk into after you leave here for people that are in the room, and people online will be doing an entire month of this in March, the 19th Amendment, and how many people, women and people fighting for the equality of women use the 14th Amendment to say, no, we can vote too. It's in the 14th. You want to just leave us with a cliffhanger on that, and then we'll come back to it either in the next exhibit or over the next couple of months.
Well, okay, sort of a cliffhanger, sort of a puzzle. So if you asked people nowadays, suppose we didn't have the 19th Amendment, which guarantees women the right to vote, what if a state said women can't vote? Well, it's sex discrimination, it's with respect to an important right. Seems like that would clearly be unconstitutional under the 14th Amendment, probably the Equal Protection Clause. And yet, the 14th Amendment has another section, which is designed to respond to sort of a weird consequence of the Civil War and the 13th Amendment, which is before the Civil War, the 3/5 compromise gave slave states extra representatives based on people that they enslaved, which seemed bad, right? It should have been 0. They shouldn't get any extra representatives for the people that they enslaved. With the 13th Amendment, slavery is over. Now they're getting full. They count the formerly enslaved as full people to determine the basis of representation. So the South is coming back to Congress with even more political power than it had before. So that seems wrong to the Reconstruction Congress. And seems wrong to me too, again, because you shouldn't give states representatives for people whose interests aren't being represented, which was obviously true when people were enslaved, still true in the post-Civil War South for the formerly enslaved. So the Reconstruction Congress says, if you deny the right to vote to the formerly enslaved, you get nothing for them, no representation. Which seems like a good way to do that, because if you're not letting people participate in your own political system, why should you be able to claim representation on the basis of their presence in your state? But it doesn't just say, if you deny the right to vote to anyone, it says, one, if it's people over 21. So there are some people you can deny the right to vote to if they're under 21. And then it says male inhabitants of the state. So the Congress that drafts the 14th Amendment clearly understands states are denying women the right to vote and doesn't think they should even face a penalty in terms of their number of representatives for that. So it's an interesting puzzle how now we think clearly this would invalidate a state law that denied women the right to vote, and yet we needed the 19th Amendment.
And male's the first time it comes into the Constitution, the word male?
Yep. So it's sort of sad. It sort of suggests some of the contradictions inherent in the Constitution, that in the 14th Amendment, which is what gives us the ideal of equality and the Equal Protection Clause, you've got this overt recognition for the first time ever of sex discrimination.
Thank you very much. It's so fascinating to spend the day talking about the Bill of Rights, but with talking about the Bill of Rights, you can't not talk about all other parts of the Constitution. It's never just one amendment or just one clause or just one section. They're all interconnected. There's also a lot more to the 14th Amendment than just what you see behind me on the law, and so much more to the Constitution. But thank you so much for sharing the stories, helping us understand the really strong connection between the Bill of Rights and the Reconstruction period and the 14th Amendment. It's been a fascinating time. We thank you all very much in person and online. Have a great day, everyone. Thank you.
Have a great day. Thanks.
Well, thank you everyone so much for tuning in to our Bill of Rights Day program. We hope that you enjoyed this talk with Professor Roosevelt. I know that I learned a lot. I hope that you all learned a lot too. I just want to let you know that I will be sending you all of the resources, all of the links, the amendments, court cases mentioned during this program, as well as a recording of it too, so that you can watch back as many times as you'd like. But again, thank you so much for tuning in. This has been so much fun, and I hope everyone is ready to celebrate the rest of Bill of Rights Day, 231 years of those first 10 amendments to the Constitution. So thank you again for joining us, and we hope to see you next time, and look out for an email from me for all of those resources. Happy Bill of Rights Day, everyone. We will see you again soon.